If you've been injured on the job, there have been some changes in workers' compensation law that you need to know about. Catherine Stone from Barbas Law is back to explain. Good morning.
Good morning. How are you?
I'm good. Glad to have you here. It's funny that we're talking about, I feel like we were just talking about how do you keep up with the changes?
Constant reading. It's probably why I have to have reading glasses now.
And this one is a pretty big change, a significant change. Break it down for us.
Well, the First District Court of Appeals, which is the appellate court in the state of Florida that handles all workers' compensation cases that come out of the judges of compensation claims offices.
Okay. Is that just for our state?
For our state,
okay.
Yes. So we have only one appellate court in the state that handles workers' compensation appeals. And for workers' compensation, the employer carrier typically gets to select your doctor for you. Typically, you must start off with an occupational health physician, unless it's an emergency type situation, before you get to a specialist. Okay. So in the law, each claimant, injured worker, gets the right to change their selection of doctor one time.
One time?
One time only.
Okay.
Now, they don't get to change and select their own doctor unless the employer carrier fails to respond to that written request within a 5-day business period. And then after that, the claimant or the injured worker would get to select. But the significance of this particular change in the law that came out last week was that the judges were divided across the state as to whether or not the claimant could select a doctor or change a doctor from one specialty to a different specialty.
But before this, what was the law? That you could have no change whatsoever?
No, you still had that right to the one-time change, but judges across the state were divided on if you were treating with an occupational health doctor and you weren't happy, could you only change to another occupational health doctor, or could you request a change to an orthopedic or a neurosurgeon or a pain management doctor? And so the judges were kind of divided in the sense of some would say, yes, you get to pick whatever kind of doctor you want to go to. Other judges maintained that no, you had to stay within the same specialty with whomever you were changing from. And the appellate court decided last week that you have to stay within the specialty with whom you're treating. So if your doctor is an orthopedic doctor, you can only change to an orthopedic doctor.
Were you surprised by the decision? Were you...
I don't know that I was necessarily surprised. I think the way the law was written, it kind of left it open for interpretation, but it makes sense that if you're changing from one doctor to another, it sounds like you should stay within that specialty.
When does this law take in effect? Does this affect previous cases or just new ones here and now?
Because it's case law, it now affects any case that's under this one-time change rule.
Okay. All right. Well, as we kind of get ready to wrap up here, what's your take home? What do you think people need to understand with this change?
Just understand that, the employer carriers initially have the right to select your doctor, and that's the hardest part for injured workers to understand. And now the appellate court has made it even harder for you to get the kind of doctor that maybe you think you need. Which
is maybe even more of a reason to make sure that you have somebody on your side, on your team, that knows these changes in the laws and what to expect, what to do, make sure everything's done.
And know what you're doing before you ask for that one-time change.
All right. Again, always a pleasure to have you on. We look forward to having you back. And there is the number, the website to call if you have any questions of your own as well.